folks are already on it, but also just ask you, as we're training, if you could just please stay on mute if you're not talking. And if you have questions during the presentation, please just drop those in the chat. This is the chat down here. If folks are not familiar with Zoom, so if you type your questions in there, I'll be paying attention to the chat to make sure that we get those questions answered as we go. The other thing, totally understand people, being kind of burnt out on Zoom, but part of what we're doing here is trying to build a renters movement. It helps, the more together that we can be, the stronger our movement is. So we'd like to invite folks, if you're cool with it, when we get into the parts where we're having discussion, we're going to do a breakout group and talk to each other a little bit. No pressure at all, but want to invite folks and encourage people to turn on your camera so that folks can see your face while we're talking. So any questions or thoughts or anything, Salisa, Kitty, anything that I missed?
No, you did great. Excited to get started.
Yeah, maybe I'll say quickly, people always ask, are you going to send out the slides? Yes, we will send out the slides. If you registered and you got the email with the Zoom link, you'll get the email with the slides.
Cool. Okay, y'all. Well, let's get going. So we're going to do a tenants rights training. This is put on by the Sacramento Eviction Defense Network. We Thursday, March 4th, 21, SacEvictionDefense.net. And if you want to join the Eviction Defense Network, we'll talk about this later, tinyurl.com/SacEvictionDefense. And my name is Ben. I'm an organizer with the SacEDN. So here's our kind of rough agenda for the evening. We're going to talk about, just to go over kind of basic eviction stuff really quick, and then dive into SB 91, which is the new Eviction Moratorium law in California. We're going to talk about SARA, which I think something rental application that you will learn more about in a little bit. And we're going to talk a little bit about tenant organizing and some victories. And then finish up with breakout groups where we'll have a little discussion. Does that sound good to people?
Yep.
Cool. Okay. Just a little to offer a little, try to offer a little bit of framing for tonight, and kind of why are we here? In the last year, a lot of us were predicting, and a lot of people all over the country were predicting an eviction tsunami, the kind of the day when the eviction moratorium ends and hundreds of thousands of people get evicted. It hasn't crashed yet, but in government, because governments are kind of kicking, state governments, federal government, local governments are kind of kicking the can down the path where there's some laws that exist. But they're not offering a ton of protection, and so the kind of the day that all the evictions happen at once hasn't come yet. But landlords don't know the law, or they just knowingly flaunt it, and so evictions are still happening. Like, we're dealing with a lot of evictions right now. It's not millions like we thought was going to come one day, but we are dealing with evictions regularly. And the eviction or the protections that exist are not enough by any means, but they are there, and they're not the answer, but they're like an important part of our toolkit that we can use for people to stay in their homes. And the SAC Eviction Defense Network was formed in the specific context of the COVID-19 eviction crisis, with the broad goal of keeping people in their homes. So we use a lot of tactics. One of them is knowing the law and being able to use the protections that we do have. So that's what we're going to talk about mainly tonight, is how do we do that? How do we use our knowledge of the law to keep people in their houses? So just real quick, eviction basics. So this is eviction law, regardless of COVID. This is just like how evictions need to be processed. So there's a couple kinds of evictions. Landlords cannot evict. They can't evict people with leases arbitrarily, but they can evict month-to-month tenants arbitrarily, which means that they don't need to have like really a reason to kick people out there month-to-month. But tenants do have protection from landlord retaliation over complaints. So like if you dealing with habitability concerns, they haven't repaired the windows or whatever, and you complain about that, and then the next week an eviction comes, you might have some protection there. There are also what are called just cause eviction laws, which means that there's a list of reasons why you can be evicted. There's usually local laws. Unfortunately, we don't have them in Sacramento or many of the surrounding cities. So you can be evicted for what are called no fault evictions, where the landlord can decide they want to kick you out. But even if they decide that, they have to do it in a specific way, and that's what we want to talk about here, because knowing how they have to do it can provide some protection. So I'm going to go through a couple of the different kinds of evictions. So the first one is a 3-day for non-payment or breaking the law, and the law being your lease usually. And it's a 3-day pay or quit notice is usually what it's called. What that means doesn't mean that you're out in 3 days. It means that you have 3 days to either, if it's because you haven't been paying rent, you've got 3 days to pay your rent. If you have a dog and your lease says that you're not allowed to have a pet, they can give you a 3-day quit, which means that you have to get the dog out in 3 days. You'll be evicted. So you can either correct the violation, pay the rent. If you can't do those things, it doesn't mean that they still have to do things correctly. And one of the main things that you can catch landlords up on is proper noticing. They have to properly give you an eviction. They have to try to find you at home. They have to try to find you at work to give you your eviction notice. If they can't find you at home or at work, they have to do what's called nailing and mailing, which means that they have to post your eviction notice in a conspicuous place, like on your door, right next to your door, something like that. And they have to mail it to you. If they don't do those things, they don't try to find you at home and at work, they don't nail it and mail it, the eviction notice is not valid, and you can fight it, and then they have to restart the process. For 30, 60, so that's for if you're not paying the rent or you're violating your lease, that's a 3-day notice. There's also landlords can evict people for what are called no fault evictions, where it's not because you're not paying your rent, it's not because you're breaking your lease in some way, it's just because the landlord wants you out. And those are 30, 60, or 90-day eviction notices for no fault evictions. And the kind of rough rules on those is that you need a 30-day notice if you've lived in your house for less than a year, 60-day notice if you've lived there longer than a year, or a 90-day notice if your house is being foreclosed on, or your home is being foreclosed on, or the landlord gets rental assistance from HUD or a housing authority. That doesn't mean that, I'm going to talk about the eviction process here in a minute. It doesn't mean that after 30 days, you're out of your house. It means that after 30 days, the landlord can start an eviction proceeding. But I'll talk about that in a minute. And it's same thing for those no fault evictions, 30 or 60 or 90-day eviction notices. They have to properly notice it, and they have to try and find you, try and give it to you in person, at home and at work. That doesn't work, nail it and mail it, post it in a conspicuous place, mail it to your home. Or for a 30, 60, or 90-day eviction notice, they can send it by certified mail, which means that you have to sign that you received it. If they don't do those things, it's not a valid eviction notice. There's also the eviction notice itself has to have the current names and addresses of the tenants and the landlords. So it has to, like, the eviction notice, everything, all the info on there has to be right, or same thing, it's not valid, especially for 3-day notices. Like, if they say you got to pay your rent in 3 days or we're kicking you out, they have to give you a very clear, in the eviction notice, very clear address and time when you can go pay your rent and who you need to pay it to. So if you get an eviction notice, really important to pay attention to all this stuff, because it's knowing all of these things and knowing how it's supposed to be done can kind of, like, if nothing else, slow down your landlord and keep you in your house longer. And the other thing that I think is important to say, evictions, so all this stuff, all of the 3-day notice, 30-day notice, 60-day notice, 90-day notice, that is the beginning of an eviction proceeding. So it doesn't mean that you're out after 3 days, doesn't mean you're out after 30 days, 60 days, or 90 days. It means that after that time, if you haven't left yet, your landlord has to take you to court. So, like, and then once they take you to court, eventually, if you lose, the court will tell the sheriff that they at some point need to come get you out of your house. That is the only way that you can be forced out of your house. Like, the landlords are not allowed to just show up and ever, under any circumstances, just show up and throw people's shit out. It has to, like, they have to go through the process, or it's not a legal eviction. So it's something we hear about, a lot. The landlords tell people they got to be out in 5 days, or I'm bringing some dudes to throw everything out. That's not legal, because they have to go through the process, and the process looks like this. So you start up here at the top left. You receive your 30-day, 60-day, 90-day notice. You either don't get out, you don't find new housing in that period, or you don't pay your rent, or whatever it is. You don't comply with the notice. Then the landlord initiates an unlawful detainer process, which is just the legalese for an eviction case. You're unlawfully detaining your home. And so they start an eviction case. Oops, sorry. And then once they start the unlawful detainer process, the tenant will receive a summons and a complaint from the court, and you've got 5 days to respond to that. And then if you don't respond, down here at the bottom, failure to respond, it's a default judgment against the tenant. So if you don't respond, it just, like, automatically goes to the landlord. And then a judge will order the sheriff to lock the tenant out eventually. But if you do want a response, best to have a lawyer to be able to file a response. And then you go to eviction court. If you win, you stay in your home. If you lose, then the judge will order a sheriff to lock a tenant out. So that is the eviction process in a nutshell. And just looking at the chat real quick. Thanks everybody for your questions, and Kitty for responding. And the other thing with that was Kitty's point. So Kitty's thing in the chat: evictions do not show up on your record for 60 days. And the idea is to allow you to find some other housing. Anything to add? Anybody I missed in here?
One thing I'll say about Sacramento specifically, with the summons and complaint, which is the beginning of the official eviction process that you have 5 days to respond to, the court also sends out a courtesy letter to let tenants know that they've had an unlawful detainer filed against them. And the courtesy letter is pretty freaky too. So you might get that and think it's the summons, but that just means the summons is on its way, and usually a couple of days after you get the courtesy letter, you get the actual summons and complaint.
Cool. Thanks, Kitty. So yeah, that is that's the eviction process. Those laws are in effect outside of COVID. They're still in effect. And they're important to know because it can be ways to just kind of, like, if nothing else, gum up the works and slow the eviction process down, knowing the noticing and knowing the process and stuff. And also I think it's just helpful to know, like, eviction is a process. Like, there's no way in which just one day you get a paper and the next day you need to be out. It takes a while. But evictions are always really brutal and always a problem. But as I'm sure folks are aware, it is especially bad right now because of COVID-19. The California Judicial Council estimates that about 900,000 households in California are at risk of evictions right now. An October 2020 report, I can't remember who did the report, but they estimated that there were 240,000 California households that owed close to $2 billion in back rent and missed rent during COVID. And that was, several months ago. So it's it's bad. And also, sorry, Sam, you've got your hand up. Do you have a question?
I just wanted to add that, but then you did it. I just wanted to add that the one of the biggest hurdles to dealing with eviction for tenants is just taking the time to go through the process, like you were saying, because as long as you're in contact with the court, as long as you are submitting over and over again, you can drag out your time, and that will give you more time to ask questions and sort of get the guidance that you need to get through this process. Like everyone was saying, even judges, I mean, I don't know, experiences are all different, but my experiences have been decent with judges when you talk directly to them. So just sometimes the fear keeps us from acting and making the phone calls and asking the questions because the system is so brutalizing. I mean, it's designed that way. So putting that out there. Thanks.
Yeah, thanks for that, Sam. Yeah, it's a scary process. It's a hard process, but the more you know, the less scary it is, and the more you know, the better able we are to fight and stay in our homes. And there we do actually have rights, which is one of the things we'll talk about tonight. That our rights are not strong enough, but we can still use them as part of a larger project of building tenant power. The current situation here in California, there's a ton of people that owe back rent that are legally evictable, or going to be illegally evictable once the eviction moratoriums are up. And tenants and advocates have been fighting for strong eviction protections since COVID and before it. There have been a series of fairly weak laws passed since last summer to avoid the kind of mass eviction event. And there are some eviction protections, but eviction courts are open. And the latest in the laws passed in response to this whole thing. And Sophia, so if the questions, Robin's right there. So the lease is up and the landlord tells us 30 days before through email that she will not extend the lease because she is selling the house. Is that considered an eviction or just the end of a contract and there's not much we can do? Yeah, not a legal notice and not an eviction either.
Actually, I might disagree on that. My understanding is that it depends on the specifics of your lease, but if your lease itself says that, the lease doesn't continue unless you proactively renew it, that could be legit. But if you're covered by just cause that people were talking about in the chat, like if you live in an apartment, for example, it's very possible that isn't enough to end your tenancy. Yeah, I'll chat our email and we can talk more about that.
Okay, thank you. And maybe in the breakout rooms, we can talk a little bit more too.
Yeah, that sounds good. Thanks, y'all. Big part of what we're going to be talking about today is SB 91, which is the newest eviction protection law in California. This is just a little bit of background. Passed on January 29th. Governor Newsom signed a deal behind closed doors to, air quotes, fix the eviction crisis. Tenant organizers and our demands were bypassed in order to pass something that was palatable for landlords. The CAA, California Apartment Association, big landlord organization, helped write the laws. But there are some things in it that we that we push really hard to get. So there is actually some helpful, usable stuff, and that's what we're going to get into tonight. So SB 91 extends protections that were passed under AB 3088, which is the last eviction moratorium law in California, that was passed in September of last year. SB 91 extended them to June 30th of this year. It also creates a rental assistance program in order to provide payments to landlords for tenants who are COVID impacted. So the state can actually pay landlords directly. And it adds a few other prohibitions to try to keep landlords from abusing the law and evicting people that shouldn't be evicted. And crucially, SB 91 does not stop all evictions. Cancel rent. Damn, man, I'm bad with the clicks. Cancel rent or provide a system for enforcement or getting the information out to tenants, which are all things that we got to figure out how to do. So SB 91 is useful, but it is not the be all end all. But what I wanted to ask folks as we kind of transition to talking about SB 91. So SB 91, not good enough, but is it important that we still know about it? And if so, why?
I'm sorry, Ben, could you repeat the question? I'm going to put it in the chat as well.
Yeah, sorry. It's is it important, even though SB 91 is it's not a good enough protection, is it important that we know about it? And if so, why? And if you got a response, feel free to just come off mute.
I see in the chat somebody says yes, so that we can use those protections.
Mm-hmm.
I would agree with that, but I think that we need to fight for better protections.
Totally agree with both of those things. Yeah, we can use these protections to stay in our homes now, but we also gotta both find other ways to build and fight for better laws, and find ways that we can use these laws to fight for better ones in the future. And with that, I will pass it off to whoever I'm passing it off to.
Lisa. Hey guys. All right, get me where I'm going, Ben. Okay, COVID rent non-payment protections. We're going to go over those. Next slide, Ben. We'll go real quick. SB 91 puts a lot of things in place that are actually somewhat helpful, but a lot that aren't, but we'll go over those too. So the first thing is tenants can never be evicted for rent that was due between March 2020 through June 30th, 2021. If non-payment was due for financial hardship caused by COVID, and the tenant, where are we at, Ben? Okay, thank you. And the tenant returns a signed copy of the declaration of COVID-19 impact. That is something that the landlord should give to you. But if not, you can find those online, and I believe we'll have a link of those just so you can be proactive. Also, you have to pay 25% of the rent that was due between September 1st, 2020 and June 30th, 2021. By June 30th, 2021. You don't have to pay 25% each month. You can pay a lump sum as long as it's all paid by June 30th, 2021. You can't be evicted for that. The landlord also should have given you, if you missed any payments at all due to COVID last year for 2020, for March 2020, should have given you a notice by February 28th, knowing your rights and how you can seek assistance. So that's that. Next slide, Ben. SB 91 extends statewide just cause to cover all tenants until June 30th, 2021, and extends protections against non-payment evictions due to COVID-19 impact. And yeah, so that is a really good thing. It pushes out for quite a few more months. And a landlord cannot go to, oh, next slide, Ben, sorry, thank you. What is a COVID-19 hardship? What counts? Loss of income caused by the pandemic, increased out-of-pocket expenses directly related to performing essential work during the COVID-19 pandemic, increased expenses directly related to health impacts of COVID-19, childcare responsibilities or responsibilities to care for an elderly, disabled, or sick family member directly related to COVID-19 pandemic that limits the ability to earn income, increased costs for childcare or attending to an elderly, sick, or disabled family member directly related to COVID-19, or other circumstances that are related to COVID-19 that have reduced your income. I think like one of the main guidelines also is if at least one person in the house can apply or is qualified for unemployment, then that counts also. Next slide, Ben. Tenants can be evicted if the court case or eviction notice happened before March 2020. And if the landlord informed the tenant of the availability of rental assistance and tenant still fails to pay 25% of the rent due between March 2020 and June 30th, 2021. That is important. I have used in my own personal case, knowing that the landlord was supposed to serve this notice and was hoping that they would participate in it, called my property management and asked why I didn't get that notice of my rights, and kind of pushed the issue and was able to get my landlord to work on getting that assistance for me. Next slide. For non-payment evictions, the noticing requirements, the 15-day notice is required to be sent by your landlord every month that you are late on your rent. And then you just have to, it's supposed to include an unsigned copy, a declaration, and then you just return the declaration saying that you've been impacted by COVID, and that's that. Then after that, they include a notice informing the tenant that you cannot be evicted if you return the declaration. In the declaration or on the 15-day notice, it must include how much rent you owe, when it became due, the name and address of the tenant, and where the payments are to be made when they're to be made. But again, you don't have to pay that 25% until June 30th. Next slide. Okay, so the notice must include this information, and I'll try to read through it quickly. Notice from the state of California: if you are unable to pay the amount demanded in this notice and have decreased income or increased expenses due to COVID-19, your landlord will not be able to evict you for this missed payment if you sign and deliver the declaration form included with your notice to your landlord within 15 days, excluding Saturdays, Sundays, and other judicial holidays. But you will still owe this money to your landlord. If you do not sign and deliver the declaration within this time period, you may lose the eviction protections available to you. You must return this form to be protected. You should keep a copy or picture of the signed form for your records. Also, very important, you will still owe this money to your landlord and can be sued for this money, but you cannot be evicted from your home if you comply with these requirements. You should keep track of everything, any messaging, email your landlords, put everything in writing as much as you can, any correspondence, and keep it safe. So you keep careful track of what you paid and any amount you still owe to protect your rights and avoid future disputes. Failure to respond to this notice may result in unlawful detainer action or eviction filed against you. Lawhelpcalifornia.org for resources. Next slide, Ben. Okay, just cause is extended to all tenants, no matter how long you've been there or what type, even if you're month to month. Evictions for substantial renovations can only be given in order to comply with major habitability issues. So if your landlord comes in, if you haven't been able to pay rent and all of a sudden they're coming in and saying they have to do repairs to get you out, they can't do that. They have to have good reason to get you out of, to evict you. The CDC moratorium on evictions has been extended until March 31st, 2021. And the CDC can be used to protect against no fault just cause evictions in cases where tenants are financially impacted by COVID. Next slide. Also, if, oh, go ahead.
I was just gonna say, Elliot had something to say in the chat.
Oh, go for it, Elliot.
Hey, I just wanted to ask for some clarification. So you were talking on the previous slide about the previous couple slides about this COVID impact declaration
Yes.
that you have to sign and send back to your landlord.
Yes.
So I know, or at least I've been told, that a landlord is required to send this to their tenant.
Correct.
If I am a tenant and it's like, and I'm waiting for my landlord to send it, should I wait for my landlord to do it, or should I proactively fill one out and send it to my landlord myself?
I would, just to cover all the bases, I would send one yourself, just to be proactive, and do that for sure. I didn't send one proactively, but I did contact them repeatedly, telling them that I knew they needed to send me one. And I just had that in writing, and in case we ever went to court, they are obligated to do that. So them not following their guidelines could result in them losing. If they take you to court, they could lose. So that's important to know also, that if they don't do their part, they could lose their case.
Okay, can I ask one follow-up based on Sam's comment here in the chat? Is this a declaration you have to sign and send every month, or do you sign it once and then you're covered until June 30th?
They are required every month that you are late on rent or behind to send you a 15-day notice, and then you are required to respond with a declaration each month.
Got it. Thank you.
Okay, next slide. Perfect. Just causes for eviction. There are two types: at fault and just cause. Yeah, just basically not paying rent. No fault or just cause. The tenant did nothing wrong, but the landlord has good reason to want them out. So if their family's moving into the unit, they're going to renovate it, they're going to not rent it any longer. Things for that reason. If you haven't been able to pay rent and your landlord comes in with one of these reasons and you believe it to be untrue, they can't do that, and you can push the issue with that. If they end up, if you wanted to take them to court and deal with those things, if they end up putting it on the rental market after you move out, you can sue them or pursue different avenues for that. But it's already after it's too late. So, but just a side note. Next slide. Okay, and then rent debt. The COVID-19 rent debt, rent is what you owe but couldn't pay between March 1st, 2020 and July 30th. Late fees aren't permitted, and they cannot take action to sue you for this until August 1st, 2021. And if you make less than 80% of the 80% of the money in your community, they can never sell your rent debt to a debt collector if you make under 80% of what everyone else makes. So landlords must supply your money to what you specify. They can't put it towards bogus late fees or your current month's rent. So if you are paying the 25% each month, or you were behind, whenever you send your payment, if you specify that this is my 25% for June or whatever it is, so that they can't apply it to any back debt. Just be very specific. They also can't use your deposit for that either, unless you specify. And next slide.
All right, I think
All
that's
right,
over to me.
It is you.
Okay, so yeah, a big part of this new COVID eviction law is what Talisa just talked about, right? There's all of these temporary protections for people who can't pay their rent, but those protections end in July, and so then there's also this rent relief rental assistance program to help people come up with the money to pay their rent debt or to, if somebody like is really strapped for cash and they aren't even able to pay 25% every month, to protect themselves from eviction, to help them with that too. And so in total, and the money is coming from the federal government. The state of California got $2.6 billion in rent relief, and they got to use it by August 1st of 2021. There's, even though it's from the feds, there's no restrictions on who the state can give the money to in terms of people's immigration status, which is great. And the only requirements for tenants to qualify for relief are that they have to satisfy at least one of the three following things. So at least one person in the household has to either qualify for unemployment or have lost income or otherwise experienced a financial hardship due to COVID-19. And like we talked about a couple of slides ago, the state has had a pretty broad definition of what COVID-related financial hardship is, right? It was like all those things about like increased medical expenses or like increased childcare expenses or not being able to work as much because you had to care for your elderly parent. Like a lot of stuff fits within that framework. So that's one criteria. Then you also can or demonstrate risk of experiencing homelessness or housing instability if you get evicted from your current place. And then lastly, the household income has to be at or below 80% of the area median income. And what that is, quick like math refresher, if you like lined up everybody's incomes from lowest to smallest and you pick the middle income, that's the median income. And that's based on household size. So in Sacramento, I think like for a one-person household, the median income is $48,000, or no, the median income is like $60,000 and the 80% of that is $48,000 a year. And then that increases the more people that you have in the house. And we actually have a slide that shows what those numbers are for different households a couple slides down. If you want to go, oh yeah. So there's kind of three like deals within this rental assistance part of the bill. One is what we've been calling the 80-20 deal. And we'll talk about each of these in a little bit more detail, but the basics of that is the state will pay a landlord 80% of the total COVID rent debt that you have if they forgive the remaining 20% and agree not to evict you, which is big and awesome. Mostly for landlords that refuse to do that. The next option is the 25% rent debt deal. So what that is the state will pay 25% of the rent that you owe between September 1st and March of this year. So like basically the rent you owe through February of this year. And what that does, of course, thinking back to what Lisa told us about, if you can pay at least 25%, then you're protected from eviction, which is really big. And then the last part is pretty similar to that. There's also, if there's still money left over from this $2.6 billion, once people have applied for the 80-20 deal and the 25% rent debt deal, they'll also pay rent that people expect to owe until July to continue to allow tenants to stave off eviction for not being able to pay any rent. All right, next slide.
Kitty, we had a question in the chat from Alexi. Could you explain a bit more what the risk of experiencing homelessness of housing insecurity means or how that might be measured?
I wish I could. There's not a lot of like specifics that we know about in terms of what people, like what that means. And so maybe that's as simple as somebody like signing an affidavit saying that they have nowhere else to move, or they would have to like double up with another family if they lost their current place. But that's a good question, and we can try and look into it more. And if we find out more, send you all that info when we send out the slides and stuff after.
Oh, can I jump in real quick? I want to, some of the indicators were like if there were late or like late utility bills, or like just like things like that, if they've ever been, or like if they get a food stamps, you know, things of that nature that are already kind of like lower income, you know, like challenges, then they are more at risk.
Oh, awesome. Thanks, Lisa. Oh yeah, Sam says behind on credit bills. Cool. Okay. Yeah, do you want to, okay. So yeah, I guess to talk a little bit more about the 80-20 deal, like I said a second ago, if your landlord agrees to accept 80% of the total rent that you owe from the state and forgive the other 20%, so that means they never expect you to pay it back and they agree in writing that they're not going to evict you for that last 20%, that's kind of like the best case deal, right? That eliminates the debt for the tenant and allows them to stay there without fear of eviction of that debt in perpetuity. And that money has to get paid directly to the landlord in every case, and the landlord themselves has to apply. And one thing that I'll note about this is that we've seen estimates that in general, like if a landlord just evicts their tenant and tries to sue them for the rent that they owe, oftentimes they don't get 100% of the rent that they're owed, because like if somebody couldn't pay rent, they probably didn't have the money for it, right? And so what we've seen is that on average, landlords are only getting like 75% of the rent that they owe if they take that route. So this is actually like a pretty good and secure deal for landlords, which can be like a worthwhile thing for tenants to know when they're trying to push their landlord to take this deal. Okay, and so then the 25% permanent rent debt deal, again, that pays 25% of the rent that somebody accrued between September 1st and September 1st of 2020 and March 1st of 2021. And that's not their total rent, that's of the rent that they still owe. So that'll at least mean that overall between what the tenant paid originally and the money that they get, that they'll have paid 25% and maybe a little bit higher if they were able to pay some rent. And that's only available if the landlord refuses to participate in the 80-20 deal. So the tenant has to apply for that. And according to the bill language, that money also gets paid directly to the landlord. Although we'll talk about this in a minute, it doesn't look like that's actually how Sacramento is planning to roll this out, which is really good, because you can imagine that a lot of landlords that didn't want to take the 80-20 deal are also not going to want to take this deal, because I don't know if they don't believe in big government or they have like animosity toward their tenants or whatever. So we'll talk more about those asterisks in a minute.
Kitty, but a question from Sam: is this the same for landlords of single properties as landlords of multiple corporate properties?
Yeah, there's no like extra support from quote mom and pop landlords unquote or whatever in this bill. It treats all landlords equally. Good question. Okay, and then lastly, yeah, the 25 in the future deal is pretty similar to the other 25% deal. If the state doesn't spend all of the money that it has in those first two deals, it'll also help people pay at least 25% of their rent for the next like 3 months until all of the language in this bill expires. And same thing, the tenant has to apply for it. In theory, it's paid directly to the landlord, although there's some extra stuff to know about that in Sacramento. Okay, next slide. So yeah, landlords they don't have to take any of these deals, but they do have to tell the tenant about the existence of these assistance programs if the tenant owes them rent. And they have to tell them about the availability of this rental assistance before they move forward with an eviction. And then I put big if true, SHRA, the Sacramento Housing and Redevelopment Agency, which is the agency that's tasked with actually distributing this money in Sacramento, they say that they will pay a tenant the 25% deals directly if the tenant qualifies for them and the landlord refuses to accept them. And so then you would have that money as a tenant and you could just pay it to your landlord yourself. And one of the things about pay or quit notices is the landlord has to accept your money in that 15-day, or well, what's now a 15-day window, it's ordinarily a 3-day window. So if you actually can get that money from the state, the landlord will have to accept it from you. Okay, so then I think we can go to the next slide. So yeah, so we wanted to talk about what we know so far about how to actually apply for this money in Sacramento. The city of Sac got a little over $30 million from this deal, and the county got about $64 million. So there's almost $100 million worth of rental assistance for the Sacramento area. There's not a limit on how much money tenants can apply for. So even if you owe thousands of dollars in debt or unpaid rent, you could potentially get all of that money. And the money can be used both to cover past due rent and utilities that you haven't been able to pay. And really important, the application to get the money is open until March 19th. So if you need to apply for this money or you know other people, make sure that they find out about it and start the application as soon as possible so they can be sure to get all of the documentation in by the 19th. But there's not, the application is open until the 19th. There's not, but it's not like first come, first serve. So my understanding is that they'll randomly look at all the applications once they've all come in. Okay, somebody's asking, will tenants know if their landlord applied for assistance, or is it the tenant responsibility to find out? So I guess this would of course be in the case of the 80-20 deal. I was looking at, I like made an account and logged in as a tenant to see what it's like. And on the tenant side, you have to supply your landlord's contact information, presumably for SHRA to contact the landlord. And I would guess that the reverse is true too. If a landlord applies, they have to give your contact information and someone would probably call you and say, your landlord applied for this money. Do you really live there? And do you really owe rent? Yeah, and do you really meet the eligibility needs? Okay, so yeah, and then the actual website to apply is apply.sarahshra.org. So, and this is what the little online portal looks like. Oh, okay, someone is saying that their landlord applied and they were notified via email that the landlord applied. So it sounds like you'll know if your landlord applies for the 80-20 deal, which is important, right? Because you could imagine that unscrupulous landlords would try and double dip and get the money and then still try and get the money from you too. Okay, do you want to move to the next slide? All right, who qualifies for rental assistance in Sacramento? Like we talked about, you have to make less than 80% of the area median income, and the priority is people that make less than 50%. And this is, I got this off of the SARA website. This is the household income limits for 80%. So if you're a single person household and you make less than $48,350, you qualify. And as you can see, the more people in the house, the higher that threshold is, on up to an 8-person household that makes less than $91,150 would qualify. You have to live, for the Sacramento money, you have to live in the city or county of Sacramento. Of course, other places in the state are also getting assistance. Big cities are doing what Sacramento is doing and distributing the money themselves. Like rural areas, my understanding is you just apply directly with the state of California to get the rental assistance. But for this, you gotta live in the city or county. At least one person in the household has to have a COVID-related loss of income or qualify for unemployment, like we talked about. And then this thing about demonstrates risk of housing instability or homelessness. Okay, next slide. And then how to apply, you have to just like make an account on this online portal, apply.sarah.shra, and that's Sacramento Emergency Rental Assistance, Sacramento Housing and Redevelopment Agency.org. And if you applied, so people call this SARA 2 because earlier in the pandemic, there was some more limited funding available, which they called Sacramento Emergency Rental Assistance 1. So if you applied for that, you have to make a separate account to try and get this money. And in terms of the documentation you need a government issued ID. You need a utility bill showing your past due balance if you owe utilities. You need a copy of your lease, which is a big sticking point. We've asked for clarification about this because of course, a lot of people don't have written leases, but they're still tenants and they've been, in some cases, living places for years. And then you need a document from your landlord showing how much money you owe, and documentation of all of your 2020 income, as well as your income for the first 2 months of 2021. And so that can be stuff like your tax return, your W-2 if you're working, benefit letters from Social Security, if that's what your source of income is, that type of stuff. And so that's why it's kind of important to, oh, what if ID is expired? That is a good question that I don't know the answer to. Yeah, the application just asks you to upload like photos of this stuff in most cases or scan. So I don't know, I guess worst possible case, I would probably upload it and hope for the best. Yeah, okay, so someone else asked, if you don't need help with rent, but you do need help with utilities, would you still qualify? My understanding is that you would, that you can apply just for utility assistance, at least in Sacramento. Yeah, and so I guess the point there too is like there's a fair number of documents that you need to round up. So that's another reason to like make the account on the portal early and start working on the application. And you can save your progress and like log in later and come back to it. Okay, next slide. Okay, so that's actually, I was like, how many slides did I put in there about this? So that's all we have to say about Sarah. I found it to be a pretty helpful FAQ on the website too, about like when will you expect to hear back and stuff like that. And then now we wanted to make things a little bit more interactive and give folks a scenario and we'll go into breakout rooms, and the idea is that we can discuss this scenario with our potentially new knowledge about tenants' rights and think about what this person's options are. I know it sounds like a number of folks also are living their own scenarios, and I would encourage you to talk about that in the breakout groups as well. Elliot, I see that you're on Stack.
Just real quick before we go into the scenario discussion, I did want to mention in conversations I've had with the officials that are going to be administering the SARA program, they did mention that if you applied for the SARA 1 program, so this was like the more limited rental assistance that was available earlier during the pandemic, if you applied for that program, but you were rejected for whatever reason, you will be given priority for SARA 2. So you do need to go in and log in and create a new account, but somehow they're going to match you up with your old account and your old application. And so, yeah, if you were waiting for like that $4,000 or whatever it was and you didn't get it, you should be given priority the second time around.
Oh, cool. Okay, that's great to know. Thank you. Okay, so yeah, Ben just dropped the scenario in the chat too, because when we go in the breakout rooms, we won't see the screen. But the scenario is Jacqueline and her 2 daughters live in Arden Arcade. About a month into the pandemic, when schools closed, Jacqueline had to reduce her hours at work to care for her daughters and fell behind on rent. Now her landlord has come to her saying that if she immediately pays back all her past due rent, he won't evict her. Otherwise, quote, she'll get a 3-day notice on her door at 8 a.m. tomorrow morning. What could Jacqueline do? So let's see. Ben, are you ready to send us to breakout rooms? Okay, I'm gonna hit pause on the old recording here while we do the breakouts.
A corporate developer and landlord that has a lot of property in Sac and outside of Sac. And we got a call from the tenant shown in this picture here, Tanya. And she was facing an eviction from her landlord. And like a lot of the tenants that we hear from, she was like, how could this happen? I heard on the TV, there's a statewide eviction moratorium, there's a federal eviction moratorium, I'm protected, right? And I was like, well, you know, not necessarily. It was kind of similar to, well, I felt like there were a lot of similarities that, you know, what she was going through to sort of my experience, where she was not being evicted for non-payment of rent. She was being evicted. It was, you know, they gave, there were a few different levels, but the reason they gave was that there was an error in her paperwork that she'd filled out. This is low income housing where you have to qualify and meet certain requirements. And there was some confusion where her adult daughter had been, you know, temporarily enrolled in a jobs training program that had some income, that she filled out this big packet, and there was some minor error. And so they basically gave that as the reason they were evicting her. She thought it was more to do with some conflicts she'd had with the on-site manager, where she'd had like a flag on her porch and some plants on her porch, and the manager kept telling her to remove them. And when she sort of argued back, then she got this notice that she was going to be evicted. So we got the call from her, and it was a tricky case because it had already gone to court and she lost her unlawful detainer. And then she appealed it and re-argued it herself and lost again. And then she'd gotten like some extensions from the court. So we got this at like, you know, way past the last minute, where it was the sheriff's lockout was imminent. It was gonna, I think the lockout was gonna happen within like a week of when we first heard from her. And so we pulled together and we got, you know, all of our different teams within our network to think about, you know, what might a direct action look like that could support her? What can we do in terms of media? What can we do in terms of legal resources and strategy in that way? And so we did a few things. I think originally we were thinking about doing some sort of like a direct action where we actually showed up at the property and tried to block the sheriff's lockout, but through some discussion, we realized that was maybe not the most strategic choice. And so what we ended up doing was, we can see here in this picture, we put together a press conference where Tanya was able to come and speak about her experience, and we got some media outlets to show up there. And at the same time, we helped Tanya compose a letter to her landlord, making a demand that they treat her more reasonably. And the combination of that resulted in, so we had, I think the press conference was on Saturday, and that night at midnight was the expiration of her final extension from the court. So the sheriffs could have showed up as early as the next morning. But with the combination of that press conference and us sending a letter the day before that, we heard back from the landlord that they were actually willing to negotiate with her. And so they canceled the sheriff's lockout. We didn't have to show up in person and block it. The media pressure and the letter was enough. And now she's in a position where it's not fully resolved, but the last we heard from her was that they were considering letting her stay for another month or so while she looks for new housing, and they were going to seal her unlawful detainer case, which is a huge deal because once you have that on your record, it's really bad for your credit, and it makes it much harder to rent somewhere else. So, and I guess the other thing that I wanted to highlight about this that was really cool is that Tanya spoke about, how she had learned a lot, because I'm sure some of you have also been in this position where you've had some issue with your landlord. And when you're in the middle of that, you've read every single thing that there is to do with your situation, right? You've read those little nitty gritty details of the law, you've reached out to people, you've figured out all of that, you've gained a lot of knowledge through this difficult experience. And she said, hey, I want to, as soon as I'm back on my feet and I've got a new place, I want to come back and help you guys. And if there are other single mothers, she's a single mom, if there are single mothers in this position, I want to share the knowledge that I've gained through going through this and help other tenants, navigate this type of situation. And so that was the other thing that I think was really powerful about this case was having our model not being that we're going to come in and swoop in and do everything for her, but really figuring out how can we work with the tenant, support her to manage her own case, and then have her feel invested in coming back and being there to support and provide mutual aid to other people in similar situations. I feel like I probably skipped over a lot of things and missed anything, but I think those were the highlights for me. And it was, it felt really great to be able to make this difference and to block a sheriff's lockout. That's really a big deal. And it, it gave her the power to sort of negotiate with them and advocate for herself once she had this group of people behind her, sort of, having her back. Does anybody have anything else to add? I feel like I just sort of improv that. Are there any other big points that I missed?
I think that's great, Joanna.
Cool.
Thank you. And I think that it's just a huge shout out. I want to echo that huge shout out to Joanna for how many hours of work you put in on that. Because it's just super clear example of time when the law was totally against the tenant, but because we organized and got together, we pushed it back, and she was supposed to be out of her house, a month ago, and she's still there and negotiating with the landlord. So the next one is the Hawthorne Suites. So Claire, could you talk a little bit about that?
Sure. So the Hawthorne Suites was a hotel in Sacramento, in North Sacramento, in which they did long-term hotel stays. So before the pandemic, people could just use it as a normal hotel, but there was also people who essentially got a lease at this hotel. And some people had been living there for like 4 or 5 years or many months. So when the pandemic started, everyone who was just a regular hotel stayer was kicked out of this hotel, but the people who had been there for over a month were allowed to stay. Now, fast forward to around November, a bunch of the, actually all of the tenants who were staying there got either 30 or 60-day notices on their doors. That's when, I think it was 2 different tenants got in contact with us, really concerned about what was going to happen. And not only had they gotten eviction notices, there was also a bunch of problems from the management. They had started moving their mail. They had restricted disabled parking and disabled access to some of the areas of the residency. And obviously the tenants were super concerned. And so it took us a little while to kind of figure out what was going on and piece the whole story together, because there was over 50 people who were living at the Hawthorne Suites at this time, and they had all received these eviction notices. And off the bat, we knew something was wrong, but we had to like dig a little deeper to kind of piece the story together. So with collaboration from 4 or 5 different tenants, being in constant communication with them, we were kind of able to figure out some of the holes in these eviction notices. Off the bat, we knew that people who had been living there for over a year were at least owed 120 days notice, not just 60 days. So off the bat, we already knew that was wrong, barring any type of COVID considerations. So that's kind of where we started building a case of what the landlords were doing that was illegal. And the more we dug in, the more we realized how Ezra Lowe, the main company, was truly, pardon my language, I don't know how to say this better, but screwing over the tenants. So once we started kind of figuring out, to cut a long story short, once we started figuring out all of these illegal things that Ezra Lowe was doing, we canvassed the apartments. Delphine was my partner here and was a super awesome team lead here. So if you want to jump in at any point, Delphine, feel free. But we canvassed the apartments, and with the help of some of the tenants who we had been more in contact with, and we got everyone's permission to write a open letter to the city to put pressure on this, the egregious harm that the management company was doing and the landlords were doing. So we got over 20 of the tenants to sign on to our open letter, and over 14 or 15 organizations in a pretty long document outlining all of the illegal things that the company was doing. And we sent that to the city in order to demand that they put legal pressure on the management company. And in this picture here, you can see the press conference we had. So we wrote the open letter, we published it with the press, we got a bunch of media involvement. And then we had a press conference where we had a bunch of the tenants who were being the most impacted come and speak and give their testimonies about what had happened. And kind of miraculously, we were able to win this case. The pressure was sufficient. The city attorney sent a letter to Ezra Lowe saying that they were defying the law and that they needed to comply with the law. And in the end, all of the tenants who were still living there got pretty big financial assistance from the management company to assist with their move out. Initially, when they were being told that they were going to be evicted, the tenants had been promised aid in their moving out, and then that aid fell through, and the tenants had just got an eviction notice on their door, so they were entitled to that money that they ended up getting. So that's just another example of the real power that having public pressure and group pressure can be. So if you are in a situation where you're in an apartment building where you have a slumlord, or you have a landlord who's trying to evict a lot of people at once, having a unified force can really do a lot to assert your rights and kind of get what you need. I'd love to open it up to Delphine to see if I missed anything in this story, but
I think you covered it well, Claire. Thank you. And yes, this was a great confluence of events that allowed us to win a crucial victory for these tenants. And the media coverage, I think, really put the pressure on the city and the city attorney's office to order Ezra Lowe to rescind those groundless evictions and eviction notices, and also to provide rental assistance. So I know that not all of the tenants were able to use that rental assistance when it was offered during the short window of time, and so there was still some problematic things that came about, but overall, this was a really important victory for most of the tenants, and it bought a lot of time for everyone to find more housing, although for some not with nearly the rental assistance that they should be receiving. Also, we have council member Katie Valenzuela to thank as well, because she spoke at that press conference.
Yeah, thank you so much, Claire and Delphine. It was an amazing victory. And we wanted to talk about one more example of a kind of a different way that the SAC Eviction Defense Network and the kind of tenant organizations can show up to do eviction defense and do tenant organizing, where the tenant and their needs and wants are really upfront. So Delphine, I was hoping you could talk about what we did down in South Sac.
Yes, thank you, Ben. In last November, one of the first illegal evictions that we responded to was in South Sacramento, and our first intervention that we did with the tenant, we had written an advocacy letter with her. Okay, let me describe the situation. This was a single non-binary mother who had a 2-year-old daughter and was being harassed and evicted in multiple illegal ways that were really traumatizing and created a very unsafe environment for the family. So she contacted us. She actually contacted the Trans and Non-Binary Housing Collective, where I volunteer as well, and I got her connected with the Sacramento Eviction Defense Network. Then we worked on 2 different fronts. The Trans and Non-Binary Housing Collective helped her with funds to relocate, since she had to do so in a hurry in order to keep a roof over her head and her daughter's head. It just wasn't an option for her to stay her ground and fight this, because things had already gotten to such a terrible level. As you can see in the photos, her belongings had been placed outside her house by her landlord. That was one of many egregious violations on his part. He had also moved in a bunch of tenants that who were not tenants in the sense of being on a month-to-month rental agreement, but rather, or on a lease, but he had instead converted a house where she was on a month-to-month rental agreement into a boarding care. A room and board. And so he moved in some recently unhoused folks who were paying a lot of money to be in an unsafe COVID environment and be served a few meals a day in close proximity to one another. So, I mean, that changed everything, and it created an unsafe environment for her and her kid. Anyway, so our first intervention was to hand deliver that letter plus the declarations of COVID-19 related financial distress for both the state law that we had at that time, which was similar to SB 91 in many aspects, and the CdC Moratorium. There was a very tense confrontation in that situation where I video recorded him yelling at us, and he reluctantly accepted the letter, but he made excuses for himself and the illegal eviction that he was undertaking, and then drove off and wouldn't accept the 2 declarations. So those had to be mailed to him. When we returned, we had a moving crew because she had asked us for help moving her belongings. This was after she was able to find a new home, and TNHC was able to cover the difference in terms of her move-in costs. So she and her daughter were able to have a safe housing despite that illegal lockout situation. Also, the landlord had the police called on her. Just really egregious stuff that was totally unwarranted on his part. So we brought a moving crew over, and this is an example of a mutual aid action that is different than an eviction blockade. It was already nighttime, but and people had to drive quite a distance often to get there. But we went out to her new home, and we went out to her old home in South Sac near Elk Grove, and we had a caravan of cars and like at least 10 people who were able to move everything, all the different bits of furniture and belongings, and bring them to her new apartment, which was 20 miles away out in Rancho. But we made it work, and many hands made light work. It was mutual aid in action, and I'm happy to say that she was able to keep her things despite all that she went through. And she wants to volunteer with us once she gets a little bit more stability in her life.
Awesome. Thank you so much, Delphine. And so good to see you. Yeah, so, you know, the Eviction Defense Network has already won some key victories. You know, there's other tenant organizations doing incredible work. It looks different with every case. You know, how we win and how we support each other looks different. I know we're coming up on 8 p.m., but real quick, want to take a few minutes and just before we go back into breakout rooms for about 10 minutes and just talk about these questions. What would a powerful renters movement look like? And how can we use what we learned tonight to build it? So just a little bit of visioning, a little bit of strategizing. And also, please, everybody, make sure you come back to the breakout room. Don't leave in the middle of it, because we're going to have a plug for how you can join Eviction Defense, the SAC Eviction Defense Network, because we need more people. Go ahead,
I wonder if we could actually, Claire just asked in the chat if she could plug in action tomorrow, and I wonder if we can do that right now, just in case people have like hard stops.
Sure.
That's super timely. Claire, you want to go for it?
Sure, thank you for opening that space up. So if you are feeling inspired right now and want to get involved in tenant protection, tomorrow there is a tenant who is facing an unjust eviction due to COVID. They haven't been able to pay their rent. They got COVID and they lost their job, and they haven't been able to pay their rent, and their landlord is trying to evict them and some of their neighbors. So tomorrow at 10 a.m., we're going to have a press conference at his apartment complex to put pressure on the landlord to do the right thing and to stop this eviction. So if you would like to join and support, his name is Anthony, help us stand in solidarity with Anthony, just send me a DM and I can send you the time and the location for this action at 10 a.m. tomorrow. Thank you.
And if you're wondering how to send people DMs, if you look in the chat, if you look down where you type in a message, you have the option to send it to everyone, which is the default. Or if you click on that, you'll see people's names. So you can find Claire's name and shoot her a private message.
Thanks, Kitty.
Anybody else want to make any plugs or anything before we go into breakout rooms for a couple minutes? Or should we just not go into breakout rooms? I feel like doing it for 5 minutes or whatever seems kind of unnecessary.
Yeah.
Maybe we just do it here. Do it live.
Oh, good combo.
Okay. People. What would a powerful renters movement look like? And how can we use what we learned tonight to build it? Go for it, Elliot.
So what does a powerful renters movement look like? There was a recent article in the news about renters in Berlin, Germany. Berlin always gets a lot of coverage because it has some very, very strict rent or tenant protections in place. And so strict, in fact, that they're thinking of actually passing a law to expropriate private property if it is not rented out. So like here in the United States, a landlord can choose to rent out their property or not. If they think it's more profitable to just sit on an empty apartment for a while, they'll just do that. In Berlin, they're thinking of passing some regulation to say you must rent this or lose it, essentially. And how does that happen? That happens with an extremely powerful and militant tenant movement. How do you build that? It takes a very, very long time. Obviously, Berlin, Germany has gone through some crazy times, as we all know. Part of that is a massive housing shortage after World War II that inspired like millions